Hello, I'm Debojit Das, and this is LiveLaw Daily. Just 2 days after independence, today carries a rather somber reminder of what freedom came with. August 17th marks the publication of the Ratcliffe Line, the boundary that divided British India into India and Pakistan in 1947. Cyril Ratcliffe, a British lawyer who had never been to India before, was given just 5 weeks to draw a border across 175,000 square miles. And with that, millions of lives were suddenly divided by a line on a map. With the importance of today in mind, let's begin with today's most important stories from India's courts. For our first story today, Rahul Gandhi has got temporary relief from the Supreme Court in a case involving allegations that he holds assets disproportionate to his income. So what has the Supreme Court done? A bench of Chief Justice of India Suryakant, Justice Joy Mallya Bagchi and Justice V. Mohana has directed that proceedings before the Allahabad High Court remain deferred for now. The CBI and the ED have also been stopped from submitting any report to the High Court at this point. This case comes from a complaint by Vignesh Shishir after the Allahabad High Court directed the agencies to verify the allegations. The matter was scheduled to come up again before the High Court on August 20th. Rahul Gandhi's lawyer, Senior Advocate Kapil Sibal, strongly opposed those proceedings, calling them unknown to law and describing the case as a witch hunt through a process not recognized by law. The CBI, however, said it was only at the stage of verifying the complaint, while Additional Solicitor General S.V. Raju described the allegations as very serious. That led Justice Joy Mallya Bagchi to ask, if it's so serious, why has your agency kept quiet? Do you require impetus from the court? The Supreme Court has also noted that Gandhi has separately sought to transfer the proceedings from the Allahabad High Court to the Delhi High Court. So for now, the High Court proceedings and the agency reports remain on hold. For our second story today, the Aam Aadmi Party's Gujarat unit has got interim relief from the Supreme Court after its Instagram and Facebook pages were blocked just ahead of the state's local body elections. So why were these pages blocked? A bench of Justice P.S. Narasimha and Justice Alok Aradhe was hearing Aam Aadmi Party's plea concerning the two accounts, which together had more than 10.39 lakh followers. The accounts were suspended in April, reportedly over copyright violations involving scenes and clips from Gujarati films used in campaign material. Aam Aadmi Party had alleged that the blocking was politically motivated and had also questioned the legal basis for taking down an entire political party's social media pages. The party's argument centers on Section 79(3)(b) of the Information Technology Act. And in simple terms, Aam Aadmi Party says that this provision can remove the legal protection available to platforms like Meta in certain circumstances, but does not itself give authorities the power to block an entire account or page. And this is the latest update. The Supreme Court has allowed Aam Aadmi Party's interim application and directed Meta to restore the Gujarat unit's Instagram and Facebook pages, subject to removal of the objectionable posts. The matter will now come up again after 2 weeks. For our third story today, the Supreme Court has opened the door for petitioners and other public-spirited persons to suggest what the investigation into alleged theft of donations received by the Ram Mandir Trust in Ayodhya should look into. So what has the court directed? A bench of Chief Justice of India Suryakant, Justice Joy Mallya Bagchi and Justice V. Mohana has allowed petitioners and other bona fide public-spirited persons to submit suggestions to the Office of the Solicitor General Tushar Mehta about aspects that may require a thorough investigation by the Special Investigation Team. The Solicitor General's office will forward those suggestions to the Uttar Pradesh Police SIT, which is already investigating the allegations. The court has also directed the Special Investigation Team, which includes a forensic auditor, to submit its status report to the Supreme Court in a sealed cover. And the court has said that it will first examine that report before deciding whether it should be made public. There was another issue before the court as well. The Nirmohi Akhada sought to raise a separate question about converting the Ram Mandir Trust into a public trust. But the bench declined to consider that issue in these proceedings, making it clear that the present case concerns the alleged financial irregularities and the SIT investigation. The Akhada has been given liberty to approach the Supreme Court separately on that issue. For our next story today, the centre has clarified an important point for transgender persons whose identity cards were issued before the new 2026 law. So what has the centre told the Supreme Court? Solicitor General Tushar Mehta told a bench of Chief Justice of India Suryakant, Justice Joy Mallya Bagchi and Justice V. Mohana that transgender identity cards already issued under the earlier law will continue and will not be affected by the Transgender Persons Protection of Rights Amendment Act of 2026. This clarification came during the hearing of challenges to the 2026 amendment, which removed the earlier right to self-identification of gender. The Supreme Court had previously questioned whether the amendment could take away rights that had already accrued. The centre has now confirmed that existing identity cards will remain valid, although the court has made this subject to the outcome of the petitions. There were other concerns as well. Senior advocate Jaina Kothari sought restoration of transgender cards that had already been cancelled. The bench said that individual grievances would have to be raised through separate applications. Lawyers also raised concerns about people waiting for identity cards, welfare benefits, and medical services being disrupted because of the new law. The Supreme Court has said that the batch of petitions will now be listed for final hearing. For our next story today, the Supreme Court is examining a question that could become crucial if India ever faces a major nuclear accident. How much compensation can victims actually receive? So what is the issue here? The court is hearing a challenge to the SHANTI Act filed by EAS Sharma and others. A bench of Chief Justice of India Suryakant, Justice Joy Mallya Bagchi and Justice V. Mohana heard the matter today. Advocate Prashant Bhushan, appearing for the petitioners, pointed out that the liability of even the largest private nuclear operator is capped at 3,000 crore rupees, while the union government's residual liability is capped at 4,500 crore rupees. He referred to disasters such as Chernobyl and Fukushima, where the damage could run into lakhs of crores. And this is where the constitutional question comes in. The Chief Justice of India asked whether these statutory caps mean that a constitutional court would be prevented from awarding higher compensation if the actual damage suffered by victims was much greater. The court indicated that Parliament fixing a liability cap does not necessarily mean that constitutional courts are powerless to award fair and just compensation. The Supreme Court has now sought a clarification from the centre on this issue and has also sought its response on Section 17, subsection 4 of the SHANTI Act concerning appointments to the Atomic Energy Regulatory Board. Notice has been issued to the Union and the Atomic Energy Regulatory Board on these limited questions. For today's next story, the Supreme Court has refused to interfere with the Election Commission's decision to use the 2002 electoral roll as the reference point for the Special Intensive Revision or SIR in Sikkim. So what is the challenge related to? A Sikkim-based organization wanted the Election Commission to issue an earlier electoral revision from 1979, 1983, 1988 or even 1993, arguing that Sikkim's demographic profile is different from other states. The Election Commission, however, told the court that an SIR had already been conducted in Sikkim in 2002 and it was therefore using the last available SIR roll as the reference. A bench of Chief Justice of India Suryakant, Justice Joy Mallya Bagchi and Justice V. Mohana declined to interfere. Justice Bagchi pointed out that the petitioner did not dispute that an SIR had taken place in Sikkim in 2002, while the Chief Justice of India also noted that no political party or other stakeholder from Sikkim had come forward to challenge the decision. The court said that the Election Commission had adopted a uniform year across the country and that choosing 2002 was essentially a policy decision. It therefore found no ground for judicial review and therefore to interfere with the reference year. The Election Commission of India has already begun considering claims and objections with the final electoral roll scheduled for September 6th. For our next story today, the Cauvery water dispute is back before the Supreme Court, this time over whether Karnataka is complying with directions to release water to Tamil Nadu. So what is the dispute this time? A bench of Justice Vikram Nath and Justice Sandeep Mehta was hearing Tamil Nadu's plea alleging that Karnataka was not releasing the quantity directed by the Cauvery Water Management Authority or CWMA. For clarity for the terms like TMC used here, TMC stands for 1000 million cubic feet of water, which approximately stands for 28.3 billion liters. Senior advocate C.S. Vaidyanathan for Tamil Nadu said that the state had received only 14,000 million cubic feet of water against the 64,000 million cubic feet of water as it was entitled to under the Cauvery Water Disputes Tribunal Award. Tamil Nadu said that there was still a shortfall of around 20,000 million cubic feet of water, even after accounting for lower rainfall and inflows this week. The state of Karnataka disputed this, as senior advocate Shyam Diwan said that Karnataka itself was facing extremely severe distress in the Cauvery basin. He pointed out that Karnataka had already released more than the 3,500 cusecs for 15 days directed earlier by CWMA. And what about the latest direction? The Cauvery Water Management Authority had asked Karnataka to maintain a flow of 12,000 cusecs from August 12th. Karnataka said that the flow had initially been around 6,000 cusecs but had risen to 12,607 cusecs by Monday morning. The Supreme Court has now directed Karnataka to comply with the CWMA's directions and called for an updated status report on the actual water released. And for our final story today, the Delhi High Court has given Arvind Kejriwal, Manish Sisodia and others one final opportunity to respond to the CBI's latest submissions challenging their discharge in the excise policy corruption case. Justice Manoj Jain was hearing the CBI's revision petition after the trial court discharged all 23 accused in February. The respondents sought time to respond to the CBI's 103-page additional written submissions, which they said raised additional grounds that were not part of the original revision petition. The court has now given them 4 weeks to file their replies, and arguments on the CBI's petition will begin in the week of October 5th, with the court making it clear that there will be no piecemeal hearing. Kejriwal and Sisodia have separately challenged the maintainability of the CBI's revision petition, arguing that it was filed within just 4 hours of their discharge order. The court said that those preliminary objections will also be considered, but the arguments will be heard comprehensively, starting with the CBI and then the respondents. The matter will now move to arguments in October. That's all for today's LiveLaw Daily episode, and you can find the links to all the stories we covered in the description box below. For more updates from India's courts and the law, keep following livelaw.in.